right on up the elevator.
We had that problem yesterday transporting access for juvenile court, but the interstate was very icy.
Okay, I have the meeting rolling. Judge Kraft?
All right, this is Chris Kraft, Chairman, calling the meeting to order. Would you call the roll, please?
Yes, sir. Chris Kraft?
Present.
Klein Lauterbach?
Present.
Linda Byford?
Present.
Stansel Ford?
Present.
John Hudson?
Present.
Hugh Harvey?
Present.
Veronica Thornton?
Present.
All members are present, sir.
All right, we definitely have a quorum. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. Such determination and a recitation of the facts and circumstances on which it was based must be included in the minutes of the meeting, unquote. Furthermore, TCA 844-108A3 defines a necessity as, quote, matters to be considered by the governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary, close quote. This is the regularly scheduled meeting for the Private Probation Services Council. The purpose of today's meeting by teleconference is to discuss the legal report and other normal business. There are two complaints that will require the council's action before the next council meeting. It's in the best interest of the council and all the parties to have complaints resolved quickly. Waiting until the next meeting is unnecessary and puts parties at a disadvantage by waiting 3 more months to have a proposed resolution to the complaint. While the council needs to address these issues, the physical presence of a quorum of the members is not possible at this time due to member schedules, the expense of traveling, and the weather. Therefore, the council has determined that it's necessary to allow participation by teleconference. So the statement of necessity is due to the impossibility of having a quorum of members physically present and the need to address the legal report and other regular business in a timely manner, the council believes a necessity exists that requires this meeting be held by teleconference. Do I hear such a motion?
So moved, Mr. Chairman.
All right, and who is moving? We need to give our names, please.
This is Commissioner Ford.
All right, is there a second?
I second that, Judge Lauterbach.
All right. Any discussion? All approving, say aye. Well, no, I'm sorry, we need to call the roll on the vote. Call the roll.
Yes, sir. Thank you. Chris Kraft?
Aye.
Klein Lauterbach?
Aye.
Linda Byford?
Aye.
Stansel Ford?
Aye.
John Hudson?
Aye.
Hugh Harvey?
Aye.
Veronica Thornton?
Aye.
All right, motion carries. Ms. Whaley, you want to give notice of the meeting?
Yes. This meeting's date, time, and location have been noticed on the Tennessee Private Probation Service Council's website, included as part of this year's meeting calendar since September 2014. Additionally, the agenda for this month's meeting has been posted on the council's website since February 27th, 2015. This meeting has also been noticed on tn.gov's website.
All right. Y'all have all received a copy of the agenda by electronic means. Do I hear a motion to adopt the agenda?
Judge Lauterbach, I move we adopt the agenda.
Is there a second?
This is Linda Byford. I second that motion.
Thank you, ma'am. Any other discussion? All right, call the roll on the vote.
Chris Kraft?
Aye.
Klein Lauterbach?
Aye.
Linda Byford?
Aye.
Stansel Ford?
Aye.
John Hudson?
Aye.
Hugh Harvey?
Aye.
Veronica Thornton?
Aye.
Motion carries.
Thank you very much. We also, every year, the first meeting of the year, have to adopt rules by which this meeting takes place. Do I hear a motion that we adopt Robert's Rules of Order for our council this year?
Judge Lauterbach, I move we adopt the Robert's Rules of Order.
Is there a second?
Second that, Commissioner Ford.
Any other discussion? All right, call the roll for the vote, please.
Chris Kraft?
Aye.
Klein Lauterbach? Linda Byford?
Aye.
Stansel Ford?
Aye.
John Hudson?
Aye.
Hugh Harvey?
Aye.
Veronica Thornton?
Aye.
Motion carries, sir.
All right, you've also received the minutes from our meeting on December the 5th. Do I hear a motion does anyone else need any extra time to review those minutes? Do I hear a motion that the minutes be
Judge
adopted?
Lauterbach, I move we adopt the minutes from the last meeting.
All right, is there a second?
This Veronica Thornton, I second.
All right, Ms. Thornton, thank you. Any other discussion? Call the roll on the vote, please.
Chris Kraft?
Aye.
Klein Lauterbach?
Aye.
Linda Byford?
Aye.
Stansel Ford?
Aye.
John Hudson,
Aye.
Hugh Harvey,
Aye.
Veronica Thornton.
Aye.
Motion carries, sir. Thank you.
Thank you very much. All right, now we will have a budget presentation from Bill Giannini.
And unfortunately, Deputy Commissioner Giannini has yet to arrive.
Oh, we can delay that then.
Yes,
Is Brian McCormick here, or they're coming together?
they are coming together,
All
sir.
right.
So we'll
Can Ms. Richardson give us her legal report this time?
absolutely.
All right.
All right, there are two cases on the legal report today. The first one is case number 2014-031-891. The complainant states that the owner of respondent entity is harassing her. Complainant received approval from her probation officer to campaign for a candidate for circuit court clerk. Respondent owner began calling her probation officer and telling the officer to find her in violation, as well as calling the court where complainant worked. Complainant must have employment as a condition of her probation, but respondent owner forced her to quit the job. Respondent owner, after being unable to convince complainant's probation officer to file a provocation warrant, filed one against complainant herself. Respondent owner also denied complainant's community service that she completed. Complainant filed additional information stating that respondent is retaliating against her for filing a complaint. One of respondent's probation officers called her to check on her. This probation officer had not checked on her in 3 months because her probation status had changed and he did not need to any longer. But as soon as she filed a complaint, the probation officer called her. Respondent states the complainant was sentenced to 2 years of probation. Complainant states that she was self-employed doing paralegal type work in the court system helping clients receive disability. She was paid an undetermined amount of cash. Respondent advised complainant that they could not verify she was qualified for this work and needed payment verification. Otherwise, she was under house arrest and could not leave. They did receive part-time employment verification from a bonding company. Complainant insists on completing her community service with a private daycare, which respondent states is unacceptable since complainant must work for a government or nonprofit entity to complete her community service. Complainant repeatedly violates her house arrest, going on errands, taking her grandchildren to school and shopping, and going to the court. And since there is no violation of the current rules, my recommendation would be to close the complaint.
All right. Any questions from Ms. Richardson about this?
Is this is Veronica Thornton.
Yes.
Is this a misdemeanor case? I mean, they are referring to house arrest. Is it a misdemeanor case or a felony case?
It was I don't remember whether it was classified as a misdemeanor or a felony, but she was convicted of getting people who weren't allowed to vote for her for a councilman position, some sort of election fraud. I don't remember exactly what classification that falls under.
Well, right now, as far as I know, we have not approved anyone to handle felonies yet. Any private probation service, we would have to do that through the Department of Correction, and they have not started that yet. So
there's no
this would have to be a misdemeanor,
right?
What's your question, ma'am?
If this is a felony probationer, there's no basis for us to deal with this complaint. Is that right?
Well, according to the statutes, probation services can do Class E felonies, so it could have been a Class E felony.
Well, let me just say this as for purpose of discussion. They did amend the statute a couple of years ago to where private probation services, private probation companies can handle e-felonies through the Department of Correction. But the Department of Correction has not adopted any rules, and they have not contracted with any private probation companies, to my knowledge, yet.
Okay, then this must be a misdemeanor then.
So it's got to be a misdemeanor. The complaint, I don't know exactly what. And Ms. Richardson, I'm ask her to speak with y'all in a few minutes about this. We're having some issues with probation companies being rude and doing things that really aren't against our rules, but they're misbehaving. And she's going to suggest, and you've received some materials about maybe tweaking our rules a little so that we can make sure these private companies are behaving themselves. But I guess the question is going to be whether or not this violates any of the rules that we have now. And is it your view that there's not a rule being violated?
Right. I've reviewed all the rules and the statutes, and even if all these allegations are correct, the respondent still would not be violating any of our rules as they are written right now.
So that if they filed a violation on this person, that would be something that misdemeanor that the judge would handle, whether or not she's violated, and handle all of that. But there's not anything we can discipline the probation company for now as far as the way our rules are now.
That's correct.
If this were true, taking this true.
How may we adopt the recommendation?
And you are?
Judge Lauterbach.
I recognize your voice.
Sorry,
but
This is Veronica Thornton. I make the motion that I second the motion.
all right. Any other discussion? All right, call the roll for the vote, please.
Certainly. Chris Kraft,
Aye.
Klein Lauterbach,
Aye.
Linda Byford,
Aye.
Stancil Ford,
Aye.
John Hudson,
Aye.
Hugh Harvey,
Aye.
Veronica Thornton.
Aye.
All right. The report is approved. Next one.
There is one other case number 2014-032101. A judge filed a complaint against a respondent entity doing business in the courthouse. During a probation or transfer hearing, the probationer, a young woman, testified that respondent owner asked her to report to his house after dark and told her about his jacuzzi, making that probationer uncomfortable and afraid of him. She also testified that respondent owner took money from her and did not report it towards her restitution. The transcript describing this incident went missing and had to be replaced. Complaint states that respondent owner complains to people in the courthouse that because of this hearing, complainant ruined his business, and therefore respondent owner stalks, threatens, and harasses her. Respondent owner will stand in her courtroom for hours at a time when he has no business there. Complainant shows proof that the owner of respondent entity posted a picture on his Facebook page of complainant and referred to her on Facebook as Satan. Respondent states that he requested the hearing in question when the probationer was granted the transfer. He called this lack of hearing a failure of due process, and the judge granted the hearing at his request. During the hearing in question, he stated that he felt he was defamed and berated as a professional, and that the hearing was a mockery of the judicial system. Respondent states that while he always conducts himself in a professional manner, respect is a two-way street. He states that his Facebook is where he expresses his opinions. Respondent denies that he stalks and harasses complainant. He does expect a public apology for her conduct at the hearing. He states that there is a separate entrance to his office, which is located in the back of his home and next to his hot tub, which some probationers ask about. He states that some probationers do request to report after work hours because of their work schedules, which was the case with this probationer. And since there is no rule prohibiting this type of conduct, my recommendation would be to close.
And I might say on the front end that I was involved in this. I wasn't the person, but I had to handle this from another body, and so I must recuse myself and let our vice chair handle the vote on this matter.
Is there any discussion about the complaint?
This is Veronica. Veronica Thornton, I have a question. When we have a complaint of this nature, do we have any means to investigate, or do we just take what the complainant says and what the respondent says? I mean, is there any way that we can verify information one way or the other?
We do have investigators with the department, but I did not send out an investigator for this case because as it stands right now, there is no rule violation to investigate, which would bring us to the next discussion on the report, which Judge Kraft, has alluded to.
Any other discussion? Is there a motion to address the complaint or the recommendation from counsel?
This is Linda Byford. I make a motion that we follow the recommendations of the legal counsel on this complaint.
Is there a second?
Hugh Harvey, seconds.
If you call the roll for the vote.
Chris Kraft recused himself from this vote. Klein Lauterbach.
Aye.
Linda Byford.
Aye.
Stancil Ford.
Aye.
John Hudson.
Aye.
Hugh Harvey.
Aye.
Veronica Thornton.
Aye.
Motion carries, sir.
That concludes the legal report.
And thank you, Vice Chair, for handling that for me. All right, Ms. Richardson, next.
Judge Kraft, if I could, if we could take just a moment break. Assistant Commissioner McCormack has joined us. Would you like to review the 2014 budget before we move into the rules discussion?
All right, that's fine.
Okay. Thank
we
you,
have
sir.
received it in our packet. Everyone would get that out, and sir, you may present.
Thank you, Judge Kraft. And why we bring this to you is the fiscal close from 2013, 14, and wanted to just use this as an opportunity to kind of go over where you all were last year. Looking at payroll expenditures, they've stayed consistent, and then if you go all the way down to the grand total expenditures, you were at $20,509, which is consistent with previous years. And then total expenditures were $33,888, which leaves you with the fiscal year balance of $93,069, which takes you to the total fiscal reserve balance is $489,458. As you can see, we're implementing the new core licensing system, and your all's portion of that. And I'll let maybe Bill Huddleston, who's here with me, accounting manager, discuss this, but kind of talk about how that expense is being divvied out.
Sure. This is Bill Huddleston, and the core expense it's across all boards and commissions, and that $222 for you guys came out of the reserve. It did not come out of operating expenses for the year. That's about, it's a small amount, but it's about 75% of the total that you will see. There will be a little bit that comes out next year, but most likely no more than that amount.
What is this, Judge Lundbeck? What is that core expense?
Core expense is a new licensing system that all the boards and commissions are implementing. The old system, or the system that we're using now, is pretty old. I think it's about 20 to 25 years old. It's been around for a while. So we're upgrading to a new system that's called Core, and like I said, it is something that all the boards and commissions are going to be using.
Okay, but licensing by whom or for whom or to whom, or where does the money go?
This is Kimberly, and I'll speak to the core. This is the system that allows us to keep up with all of the companies that are registered.
Is it like are we talking about a computer system? Or?
Yes, sir. Yes, sir. It is the licensing system. The Division of Regulatory Boards has somewhere in the neighborhood of 230,000 active licensees, and our current computer system that we use to track.
Okay, that's fine. This is just we're paying a licensing fee for a computer. We're paying a share of a computer system. Okay.
Yes, sir. Yes, sir. This is the small portion for the Private Probation Service Council.
I can tell you all, this is Brian McCormack, I can tell you all that this is you all definitely have a very small contribution to that pot compared to a lot of the other boards. So, and I did want to just take a moment just to focus on, and if y'all have any questions, please stop me. But as you notice, the fiscal year balance this year was $93,000, and that I just want to kind of point out, and for y'all's conversation, that's pretty high compared to the amount you all are taking in. So wanted to bring that to your attention. Do you all have any questions?
Well, this is Chris Kraft. I have one question. We when we started this out in 1997 or 1998, we started earning deficits. Had a pretty big deficit, and the legislature was thinking about sunsetting us at one point. But we got everything together, got the rules passed, and we assessed $1, I think, a quarter for each probationer. And our determination, this was about 10 years ago, was that at some point, after we'd paid off our deficit and had a surplus, we were thinking about reducing that fee for the probation companies who are having to pay thousands of dollars a quarter, some of them, and passing them on to the probation companies, passing them on to their probationers. And last year I talked to Bill Giannini about this, and he says we don't need right now to be we need all these surpluses, the state government, and was basically saying, please don't try to reduce any revenue because we're having a problem with the state. But at some point, it seems like we ought to reduce the fees that we're charging now that we are in the black and are pulling a surplus every year. That was just kind of the will of the council a couple of years ago. So I didn't know at what point we could start doing that or take a look at that.
I'm going to turn over to Kimberly for this.
Yes, Judge Kraft. Yes, I recall that conversation and am familiar with that. We do feel that this is as we are. We paused on Ms. Richardson's discussion of rules. We do feel like this may be the time that we do pursue that and look into that. So I think it is a very timely conversation that we can have as we go forward this year about lowering the fee and finding what the best fit fee is that ensures your self-sufficiency while still being fair and not constantly adding almost $100,000 to your reserves each year.
Right, and we need to find an equilibrium, and because it eventually is passed down to people who are placed on probation who needs to be paying their court costs and things like that rather than the private companies. Okay.
Yes, and we certainly can continue that conversation when we start discussing the rules here in a few minutes.
All right, that'd be great.
Have any other questions regarding the financial report?
This is Veronica Thornton. I have a question or a suggestion I might add to the reduction in fees. I think that it would probably be good. I know that without a doubt most of the cost for the provider fee is passed down to the probationer. When the fee is reduced, I think it should, if possible, be mandated that that additional fee that goes to pay the provider fee that is assessed to the probationer, that they have to remove that extra fee from the cost that the probationer pays.
Instead of just collecting profit.
Right.
Right.
Because you know as well as I do that's what they'll do.
Yes.
That's all I have.
Thank you. Anything else? Thank you, sir, for your presentation.
Y'all.
All right. Now, Ms. Richardson, do you wish to continue with the rulemaking?
Yes, I wanted to bring your attention based on the legal report and a couple other instances we've become aware of that didn't become official complaints, that there may be a need to consider new rules, because the statute governing the Private Probation Services Council says that we have the authority to adopt uniform professional and contract standards in our rulemaking, and we have the authority to adopt professional conduct rules. We have not done that, and based on these reports or this legal report as things that have come up, I wanted to bring it to your attention that it might be worth considering.
All right.
And so I emailed out to y'all, I did a little bit of research from different states. There are about 10 other states that allow private probation. All the other states just do it through public. And so I printed off and sent to you, just kind of examples from Georgia and from Utah of the type of rules they have. And I kind of compiled a little, sort of like a brainstorming list that was my other PDF that I sent out of, potential things the council could look at if it wishes to do so, just examples from other states that I've found. I wanted to throw it to you and see if that's something you wanted to look at, think about, just review, discuss. And I'll just let y'all take it from there.
Well, let me just say this, and I recuse myself from the vote on the hot tub case, but we're having issues with, for instance, a probationer will accuse a probation employee of improprieties. You don't know if the probation employee is being improper or if the probationer is making things up because they don't want to get violated. Then when there's a violation hearing or there's a complaint made to the judge gets involved, and the judge has the power to stop assigning in counties that have more than one private probation company like Shelby County. They say, well, I'm not going to use you anymore. And then the private probation, then they'll complain against the judge, or there'll be things said on the record about this person or that person. And so it would really nice if those things came before the council, so that we could kind of cut through a lot of that. I I know we had several years ago, we had a lady that actually came before us when we met physically and said that her daughter wasn't using drugs and they were faking the drug screens. And I said, ma'am, you need to file a complaint about that. And she, instead of filing a complaint, she filed a $5 million lawsuit against me in federal court for not letting her have her say. And we really couldn't do anything on our own with a lot of this stuff, because when we first started promulgating our rules, we stuck to the statute. But, Ms. Richard, you say that we have statutory authority to pass conduct rules.
Yes, we do. It says in multiple or a couple places throughout the statute that we have the duty to promulgate uniform professional standards and uniform contract standards. And so I think that gives us broad authority to adopt some sort of professional conduct rules, similar to what these other states have done.
Having a probation office in your house?
All right.
This is Judge Lauderback.
So can you repeat the question?
I said, do the rules extend to saying you can't, I mean, if you say we can propose private conduct or conduct rules that relate to the private companies, would that be so far as saying you cannot have a probation office in your house? I can't imagine somebody approving a probation company that uses their house for their office.
I can't imagine anybody wanting to do that.
Well, that's an even better question, but why would a judge ever agree to use somebody like that? I just don't understand that. But can we put that in our rules that you have to have an office, not in your home? I mean, anyway, it sounds sort of strange to me.
Yeah, that's definitely something we can look at, and I'll be discussing with the Attorney General's office. They review all the rules, to make sure we have the authority to do it. And I'm confident that we have the authority to do professional conduct rules. Office, branches in a little bit farther, so I'd have to check up on that. But that's definitely something I'll look into and get back to you for the next meeting.
And I guess what she's looking for here, this is Chris Kraft, is just where we're leaning. If we're inclined to do this, then getting some rules together that the folks that work for the department deal with, and to get some rules together for us to look at and get us to approve them, then we would have to promulgate them. We'd have to have the public hearing and all that on the rules. But she wanted to make sure before they did this work that would be something we thought would be proper to do.
Judge Kraft, this is Veronica Thornton. I have a question.
Yeah.
Instead of us looking at Georgia and whatever this other state is, does TDOC, do they not have state standards that cover things like professional conduct?
Yes, we are looking into their conduct rules as well, and we would definitely look at those and incorporate them when we brought the rules back to you. If this is something you wish to proceed with, we would bring those to you as well at the next meeting.
Well, I don't see a need to really overhaul all the rules we have, but obviously there needs to be something regarding professional conduct, and I would think that, since we operate in Tennessee, that surely the Tennessee Department of Correction has some rules that we can go by or maybe even adopt.
Yes, I can get those to the council to have y'all review it.
So I guess generally, is anyone opposed for this discussion? Is anyone opposed to our going a little further in the regulation and letting them present to us rules that they suggest, drawing from different resources, rules that they suggest would be rules for us to promulgate, and so that they could send them to us, we could look at them, and then we could discuss them at the next meeting.
Do you need a motion for that, or just sort of general consensus that we?
Yeah, I just want to see if there's anyone that objects to that. That feel, when we first started, we were very careful about when we made rules, because we wanted to make sure we followed the statute exactly, because we have a lot of lawyers and judges on the council, and we gave the Attorney General's office at that time, who was handling this for us, we gave them fits because they would keep changing things and we'd change things. But I guess what we need is we would need something concrete to look at, and if no one's opposed to that, then I think that'd be something great for them to do for our next meeting.
And I would need a motion to proceed forward with potential rulemaking as well.
Didn't know that.
I move that we proceed forward with potential rulemaking relating to rules for private conduct, and that you, in your preparation for that, you propose some rules, and then bring along with that copies of the rules that currently used by the Tennessee Department of Probation.
I can do that.
All right, is there a second?
This is Linda Byford. I second that motion.
Any other discussion? All right, call the roll for vote, please.
I do have one final matter. We had a moment.
I think we need to vote on the motion. Did you want to have?
I actually was. We may want to amend the motion.
All right.
Related to also investigating the potential of lowering the fee inside, if we're going to do rules.
I see.
Then I will amend my motion. This is Judge LeBrecq. I'll amend the motion to include wording that you also pursue that rule changing.
And ma'am, as the second, do you accept that amendment?
I do accept the change in the amendment.
All right. Any other discussion? Call the roll and vote, please.
Okay. Chris Kraft.
Aye.
Klein Lauterbach.
Aye.
Linda Byford.
Aye.
Stancil Ford.
Aye.
John Hudson.
Aye.
Hugh Harvey.
Aye.
Veronica Thornton.
Aye.
Motion carries. We will look into rules and present information.
All right. Would you refresh our memory as to the process, that the steps they have to go through before rules actually are made?
Yes, well, the council would, I guess, consider what I present at the next meeting. They could adopt the language of the rules they want to carry forward, and then we would do a rulemaking hearing on those rules. And then, there'd be public comment, and the council can vote after that hearing to either change the rules based on the comments or adopt them as is, and it would go forward and we filed them with the Secretary of State after the rulemaking hearing, and that's pretty much it.
All right. Well, that's pretty. I knew it took a little while. So the companies will have a chance to comment if they disagree with these rules.
Yes, there will be a rulemaking hearing, and I left out that the Attorney General's office will review the rules for constitutionality as well, just to double check everything.
Okay. All right. Ms. Richardson, you have anything else?
Nope, that is it. Thank you.
All right. We've got then, Ms. Whaley, we have your budget report.
Yes, sir. And what I presented to you is just the current financial position of the Private Probation Service Council as of January 31st, 2015. Currently, if we close today, we would put nearly $60,000 in the reserve. Of course, this is only halfway through the current fiscal year.
All right.
It's just for informational purposes. If anyone has any questions or comments.
Any questions for Ms. Whaley about the budget report? All right. Complaint performance measure update.
Yes, and just because I added this to the meeting this time because we have had historically the Probation Council has had very few complaints, and I just wanted to let everyone know we have a performance measure here in the department that states that we will resolve all complaints resolve or refer for legal action within 180 days of receipt, and we strive to do that 80% of those 80% of those within that time frame. And just to let you know, we're doing very well. The meeting schedule is working for us. So just because we have had complaints that we have not had in the past, I wanted to bring that forward.
Thank you very much.
Mm-hmm.
Any other questions about that? All right. Now let's talk about House Bill 427. I think y'all received that by email.
Yes, and this is a piece of legislation that has an indirect impact on the council. So I will yield to Ms. Richardson, and for any questions. But
yeah, I mean, the House bill is pretty straightforward. If it passes, it will allow private probation companies to serve probationers that have a Class C, D, or E felony.
In the past, when we've discussed this in the council, we've not been too excited about having private probation companies handling people with C and D felonies. And would this be going through the Department of Correction, or would this be directly from the judge? That's the question that I had. I had trouble figuring that out.
If it goes through the corrections currently with the e-felonies, I don't see anything that would change that process.
Because, in other words, we used to have, when we first started, we had judges handling felony cases and putting people on probation on felonies with prior probation companies, and they could not do that. We had to send some cease and desist letters to judges because the Department of Correction contracts with them to handle their probations, but now they can't probate a C or a D felony, and that's why I don't know if this bill has any traction or not. But the Department of Correction can't put somebody on probation. They could maybe use them to supervise their parole, but right now there's not a provision to put. They have a determinate release for a sentence of 2 years or less, but if it's a C felony, it would have to be a minimum of 3 years. So I think this would need some work before it could be practicable. But do you know if anyone's pushing this bill?
I am unaware.
I'm not aware either. I can certainly research and see. This was just something that was filed that we wanted to make everyone aware of. But we will. I can certainly look into that. I do not know where it currently is. When it was filed, it was only a House bill. It did not have a Senate bill. So if it does not currently have a companion, then it probably has not gained traction. But I can certainly.
Well, I'll go through the judicial conference and we'll track it. But I just don't think right now the way it's worded, it makes a lot of sense.
Judge Kraft, this is Veronica Thornton.
Yes.
I have some information on this.
All right.
There was a request for, to determine if there was any interest among the private probation companies that qualified. There were certain requirements that had to be met before a private probation company could qualify to contract with the Department of Correction to supervise the Class C, D, and E felons. It was the information that I got was that they were not assigned by the courts. They were not assigned by the judge. They were assigned by the Department of Correction, and it would only take place in a district or an area where the caseloads of the Department of Correction probation officers were overloaded. And Department of Correction would assign those to the private probation company, and there was no funding to be provided to the companies for that. They were simply to charge, and I believe, my memory serves me right, a $60 a month supervision fee. And of course, I don't think there was very much interest in it at that time.
Well, by statute, our council has to approve companies that the Department of Correction contracts with.
Right.
And they've never asked us to approve anyone because they've never contracted with anyone yet. So
well, their requirements were so extensive that I can't see that anybody would be interested.
Right. Now, the companies are kind of scared of that. So, okay.
Yes, and I just looked it up. It does have a companion, and it was last in subcommittee of state government subcommittee of state government committee. It was taken off notice on 3/4, and it passed in the Senate on 2/12. And this was the Senate it's now being referred to the Senate Judicial Committee. This can almost change by the minute sometimes. So that's
when it's taken off notice, that's pretty bad. If it goes to Senate Judiciary, they'll probably put it off for a year and look at it. So. But I'll track it, and I know we can't meet by phone unless we have a meeting. But I'll let you know, Ms. Welly, what I found out about it.
Okay, that would be wonderful, and I will. The department tracks these as well, so we will stay on top of it and provide updates at each of the meetings. That's a standard operating procedure for each of our councils, commissions, and boards. So.
Does that have anything to do with private companies handling probation for misdemeanors out of criminal court? Do they do that?
Private companies can handle misdemeanors from courts of record as well as
General
General
Sessions Court. Okay.
Right, right.
So all we're talking about is whether we add felonies to it. So.
Right, and right now the statute says that they can do e-felonies if the Department of Correction contracts with a private probation company that we approve them to contract with.
Okay,
Then they can handle probation for the Department of Correction on determinate release. They'll somebody gets 2 years or less, they can probate them themselves without coming through the courts, and they can choose the private company to monitor them instead of their own parole officers or probation officers.
This bill would definitely, as far as from a departmental standpoint, of course, it would be relatively no impact for us, but it does affect the industry. So,
yes,
we do keep track of these things.
and also the more serious cases they handle, the more potential there is for abuse with private. Same issue with private prisons and government prisons. You know, private prisons, they don't need to spend as much on food because it cuts into their profit. And so there are certain temptations that come. So anyway, any other discussion about that potential law? Any other new business to come before the council? Anyone have anything else? Well, I must say I'm excited that we're getting to the point where maybe we can lower our fee and handle some conduct issues, and I really appreciate everybody braving the ice and snow to call in today. Thank you all very much.
You're welcome.
All right, do I hear a motion to adjourn?
Don't move, Mr. Chairman.
Okay, and before we vote on that, I don't think we need to vote, but make sure and turn in your conflict of interest back to Ms. Whaley. Can we sign it and fax it in, or do you need the original mail?
No, sir. You can fax, scan, email. Any way you wish to return that to me is greatly appreciated. It will make HR very, very happy and will keep me out of hot water.
So if y'all, before you go home to ski today, if y'all will fill that out and sign it and fax it to Ms. Whaley, I'd appreciate it.
Yes, thank you. And I do have to say I have received a few already, so I appreciate those members that have already sent them. So.
Thank you very much. All right, then we'll show the meeting adjourned. Thank you.
Goodbye, everyone.
Good weekend.
Good weekend. Bye-bye.